I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. And I'm going to throw a term out at you that you've probably heard many, many times if you've been watching Court TV and watching trial coverage through all these years. The battle of the experts. The battle of the experts. Hear it many times. It's happening in the case in Minneapolis, the case against Kim Potter. It also happened in the Derek Chauvin trial. And something unbelievable happened in that case. There was an expert who almost achieved sainthood. He was the most credible expert in the history of any trial. At least a lot of people said that, okay? And obviously I'm exaggerating just a little bit here, but in that battle, he won that battle, and we know he did because of what jurors said afterwards. Of course, I'm talking about, or maybe you don't know who I'm talking about, Dr. Martin Tobin, who was the pulmonologist, the expert who really turned into more than an expert. He won the case for prosecutors. He absolutely did. And one of the reasons was because of one part of his testimony. Do you remember this?
Would you tell the ladies and gentlemen if you're getting paid for your time in this case?
No, I am not getting paid.
And why is that?
Well, when I was asked to do the case, I thought I might have some knowledge that would be helpful to explain how Mr. Floyd died. And since I'd never done this type of work in this nature before, I decided I didn't wish to be paid for it.
They never say that. Experts never say it. No, I have some knowledge. I know what this is about. No, I don't need to get paid. I don't need to get paid. And that just took his testimony and his credibility from here to here, because that's what the battle of the experts is all about. It's about credibility. And I remember during that trial talking about that moment and how that elevated his credibility, because the defense was not going to have an expert come in and say, you don't have to pay me for this. Of course, they get paid. It's normal to get paid. It is a normal part of the process. The thing that is not normal is when the expert testifies and is not paid. So let's go back to the trial that we're covering now in the same courtroom, in the same courthouse, same prosecution team. But now we're in the defense case. And the defense use of force, which is what this case is about, in part, use of force expert testified. Take a listen to what he said.
Are we paying you to be here?
No, sir.
And why is that?
I've decided in the mid-90s when this process began, I began asked to review cases that I would never take a fee in a criminal case regardless of the side that was calling me. I'm not Mr. Benevolent. I like to get paid like anyone else. But I just felt that something as significant as someone's freedom suggested I should give an opinion without any question about motivation. I may say things you don't agree with, but I don't think the issue of money coming into it should be a consideration. So I just decided in the 90s I would never take a fee for a criminal review of any kind, regardless of the initiation, but I've stood by that, and if I continue to do this, I'll continue to take that perspective.
Unbelievable, right? And I've been telling you, this is not the Derek Chauvin trial, and it's much different, and things are turned this way. And with the experts on that issue, absolutely, big difference. Battle the experts. Who wins the credibility there? The one who says, no, I just come in and give my opinion. Well, in Derek Chauvin's trial, Dr. Tobin won that battle. Now the question is, will Stephen Imes, the expert for the defense, win the battle in this case? Let's bring in Court TV legal correspondent Chanley Painters joining us live from Minneapolis, Minnesota tonight. Unbelievable. I know we were kind of exchanging text messages and everything today about this whole thing. Chanley, so he doesn't take a fee. What did he have to say to this jury?
He had a dynamic, direct examination, and he comes from a position of experience, 43 years in the law enforcement business, and that was noted by these jurors in those reporter notes, Vinny. His background as a police chief, as a trainer, as a use of force expert, working for free, and he had opinions based on his view of the body cam video, the dash cam video in this incident. He talked first about his opinion on whether or not the use of a taser, which we know Kim Potter intended to use that day, was appropriate. Let's listen.
Was Officer Potter's perceived use of a taser consistent with contemporary and professional police training and practice?
Yes, sir.
And why?
The basic model policy definition of when the device would be used is completely relevant here. Grounds to arrest or detain, and a reasonable belief that physical force and resistance would follow. That was happening right before your eyes. And secondarily, when the physical control effort began and the dynamic nature of how he's trying to get away clearly needs to be stopped. Just getting in the vehicle is significant, but officers would be aware of that weapons component and the concern, could there be a gun in the car? Could there be a gun on him? This isn't just about might this person drive away. So the need to stop it as quickly as possible is the key aspect. Nothing but the taser in that scenario had a likelihood of doing that without a risk of serious injury or death. The continued grapple, if you don't get that done and that car gets in drive, it's going to get bad. And the taser is that unique device that when performing as designed and intended would have put a stop to it, very, very likely in most cases.
The officer sees Johnson in the car,
Yes,
sees him struggling in the car and has a view of him. And further, that the individual is about to drive away, or at least attempt to drive away, with an officer who's in and out of the car. Would that officer who sees him be reasonable in the use of deadly force in the face of Mr. Johnson's apparent risk of great bodily harm or death?
I'll object, Your Honor, as calling for speculation and improper standard.
The objection is overruled. You may answer.
The question, sir, would be answered first by just understanding the basic decision-making process involving deadly force, and that is, can I reasonably articulate a belief that myself or another is in immediate danger of risk of death or great bodily harm? So if that's the standard, as an officer assessing the appropriateness of deadly force, an officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
Okay. So an officer seeing that could shoot?
It would meet that standard and an officer could shoot, yes, sir.
So this use of force expert Vinny saying that a taser would have been appropriate under the circumstances, and if Potter was aware that Sergeant Johnson was half in and out of Wright's car at the time, deadly force would have also been appropriate. He also spoke to that warrant, that it's a dereliction of duty for an officer not to execute an arrest when someone has a warrant out for their arrest.
How about on cross-examination? What happened there?
Right. Well, Matthew Frank tried to change the narrative a little bit. He pointed out that this was an expert who talked about deadly force, but with that caution of whether Potter knew that Johnson was in or out of the vehicle. That seems to be a main point of contention. Whether Sergeant Johnson was halfway in or halfway out, this expert was said, well, he was more out than in, so he made that point on cross-examination. Also, there was a moment where Frank said, wouldn't it be a dereliction of duty, using his words on direct, for an officer to use unreasonable force? And he agreed with that. No major mountains were moved on cross-examination, Vinny, but a couple little things to try to get him, this jury, to look back to what this prosecution wants them to believe.
Okay, how about Kim Potter's former boss, the old police chief from Brooklyn Center, testifying today?
Right. He was also a powerful witness for this defense. He was, again, the police chief at the time that this happened. And he told this jury not only that, Kim Potter was a good person and a good police officer, but that he also reviewed the body cam video, and under his, expertise of the policy and the procedure of the Brooklyn Center Police Department, that he reviewed all three officers, what they did in that traffic stop. It was all appropriate. He also told this jury, under the circumstances, it would be reasonable and necessary to use a taser in the incident, and under that circumstance, if Johnson indeed was half in that car, to use a gun in that circumstance. But on cross-examination, again, the prosecutor tried to undercut some of that by trying to expose some motive or bias. Let's listen.
Officer Potter, or Kim Potter, was involved in the shooting incident, and the aftermath of that related to the political pressures within the city. I was no longer allowed to stay as the chief of police.
And was that because you would not terminate her until she had a due process hearing?
Objection made.
The objection is overruled on that ground. You may answer.
I believe one of the reasons that I was required or requested to leave the agency was because I would not immediately fire Kim Potter.
Did Kim Potter leave voluntarily after that? Quit her job?
She did resign her position to me while I was still the chief.
Vinny, that was on direct examination, but it was again brought up on cross by the prosecutor, trying to point out that he might have some affinity towards Kim Potter. In fact, that he lost his job because he wouldn't fire her over this incident. He also spoke to the media since that time, talking about the political pressures, and that was a consistent theme on cross, not only for this witness, but for a lot of the other character type witnesses later this afternoon.
Chanley Painter in Minneapolis. We'll talk again a little bit later on in the program. Thank you so much. Let's get some reaction from our think tank tonight. Joining us in the Bronx, New York, criminal defense attorney Renée Hill. In Houston, Texas, criminal defense attorney Carmen Rowe. And in Atlanta, Georgia, criminal defense attorney, law professor at Emory University, and Georgia Innocence Project board member Molly Parmer. Welcome to all. Battle the experts. Was this a knockout? Was this a TKO? Was this a draw? What happened here today, Renée?
I don't want to say it was a TKO, but I think it was a very, very good day for the defense. This witness was excellent for them. He presents very well, the use of force witness and her boss also. They both presented very well. And the prosecution's cross-examination of these witnesses has not been good. It's just really not up to par. It's very, very different from the way the prosecution was in the Chauvin case. So I think that the defense witness here that they have on, their expert witness, has produced a lot of information for this jury to give them a reason to find reasonable doubt.
Carmen Rowe, every opinion in this case so far has been that the taser was proper, the use of a gun was proper, except for one person, the paid expert from the prosecution. What does that mean to the jury?
Vinny, I'm having trouble with this. I'm trying to be objective. I agree the defense is killing it. I think that the prosecution is not doing the kind of work that you would expect them to do. But I have this fundamental problem, even listening to all these experts come in with this notion that the taser was okay or that shooting under these circumstances was okay. Every time I listen to these experts, it sounds like any time an officer is presented with a potential danger like the one that we saw here, albeit speculative at best in a lot of this testimony, it's okay to tase and it's okay to shoot. So I don't know if the people at home and this jury is looking at it the same way I am, but I have trouble with that. And again, I'm trying to look at it objectively and to be reasonable about what they're saying and to believe what they're saying. But I'm having trouble with it. But I do think that the defense is doing a great job. And I think for right now, it's their case on these issues, unless there are people like me who just have trouble with this fundamental idea that officers can shoot and kill people under circumstances that, again,
I'll lay this out to you,
speculative.
because I asked this of some other guests the other night. And I'll get to you, Molly. Wait, Molly's still waiting. She's ready. But Carmen, what do you want the officers to do? What do you want him to do right there?
Of course, I want them to be better trained. I mean, they talked about...
No, in that situation, Dante Wright is attempting to drive away in the car. They don't know if he has a weapon in the car. They know he has a warrant for a charge related to a weapon. They know that there is a restraining order against him against a woman. They don't know if it's the woman who's in the car, and the officer is 1/3 of the way in the car on the other side. So at that point, what do you want Kim Potter and Officer Lucky on the other side to do?
To be responsive but not proactive. I think they step back, they ensure their safety first, deal with these misdemeanor offenses they've observed second. Everything else is speculation.
You're going to let him drive away?
Absolutely. Misdemeanors for sure. I'm not killing anybody over a misdemeanor. I don't think police should be justified in that. That's all they knew he'd done.
What if as he's driving away, Officer Johnson gets dragged? You're okay with that?
From what I've heard, that's not certain. That's speculative. So if she acted based on that, perhaps we're in a different space.
Well, that's what we're hearing.
That's what
we're hearing. That's what we're hearing right now.
Well, we're hearing that may have happened, but that she wasn't even clear that she saw that in this case. That's what I'm saying. It's speculation at best where we are. Now, if she said, look, I saw my partner in danger. He could have been killed. That's why I reached for my taser or my gun. But that's not what we're hearing.
Right, Molly?
She's saying maybe that was the case.
Well, she thought she was going to tase him. And the prosecution said tasing's no good under this situation. Molly, there's a protective order, right? They know that there's some restraining order, protective order that Dante Wright is a subject to involving a woman. They don't know if it's the woman in the car or not. Are you okay? Someone has an outstanding arrest warrant related to a weapon, protective order against a woman. There's a woman in the car. Let him go.
I agree wholeheartedly with Carmen. And yes, I love this phrase that she used, be reactive, but not so, be responsive, but not reactive. And I think that in this case, we have to remember, for me, one of the most powerful pieces of testimony that I heard was Officer Lucky when he said the reason for the stop was an air freshener hanging from Dante Wright's mirror. That's what started all of this. Do I think that we should have cops patrolling the roads and pulling people over for a car freshener? I think that's excessive to begin with. And then you find out that he has warrants and he's trying to drive away. I think you let him drive away and you send the marshals out, you send the sheriff out, and you arrest him. And everybody, I think, in that situation would be in a much better place today. But I think Carmen is spot on. She's correct. And you never know with the jury. I think the fact that the defense
Why would the next arrest
said,
be any better? Why would the next arrest be any better if he's not going to go voluntarily on the side of the road with 3 officers around him? Why would he go when you show up at his house? Why would that be any better?
Because at that point now you have a tactical plan. Mm-hmm. It's a totally different situation. It's not as chaotic and dynamic, like all of these people surrounding a car and just, reacting at whatever's coming at them. It's a totally different situation when you have a team out that's effectuating an arrest. That's a totally different style.
Okay, let me ask you this, since we're in the world of what if the protective order was for that woman in that car? And what if he ends up hurting that woman in that car, and then all of a sudden we find out, well, they pulled him over and they knew there was a protective order and they let him drive away. How about that, Renee Hill?
So you're throwing a lot of what ifs out here, and there's no indication here that the young lady gave them any indication that she didn't want to be in the car with him, that she was feeling like she was in harm's way.
You've done work in domestic violence. You've done work in domestic violence. You know how the victims of domestic violence oftentimes are back with their abuser, sometimes voluntarily, sometimes not.
That happens a lot. And a lot of times they don't want the order of protection, and the prosecution won't drop the order of protection. So you can't say just because there was a woman in the car and he has a domestic violence.
I remember when police pulled over another couple and let him go. When they pulled over that other couple, let him go, and Gabby Petito ended up dead.
And in that case, Gabby Petito was extremely upset. She was crying. Mm-hmm. Her demeanor was very, very different from what the demeanor of this young lady is. So you can distinguish between the two.
All right. Is there any responsibility for members of the public to comply with police? Is it a social contract between police who risk their lives to keep everyone safe and the public to comply when you say you're under arrest?
You should certainly comply, Vinny, but if you don't, you shouldn't end up dead. And I have a problem with this case, as you know, from us talking about it many times, that even when Officer Potter or Kim Potter was saying, I'll tase you, before she says taser, 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 she says, I'll tase you. She had it in her hand already. And she should have seen it was her gun and not her taser. So I have a problem with that. And then they also
And
that gets to
the issue of the level of recklessness. That's exactly what the jury's got to figure out.
Yes.
You're not saying it's on purpose. You're not saying it's on purpose, right?
It's negligence. It's criminal negligence, I believe. And then the other issue about him speeding off, and that they're saying that the other officers were in harm's way. And in my opinion, the moment in time from what I see of him speeding off is after he's shot. And that's a reaction to being shot. And then the car begins moving.
It's also a reaction to Officer Johnson getting out of the car as well, because he was holding it in park. He was the one preventing him from driving away. So a lot of moving parts. Great conversation. You all know what you're talking about. Police officers I've had on this show disagree 100% with all three of you, but we'll continue this conversation today. When we come back, let's talk about what's happening in New York City, where Renée is tonight. Ghislaine Maxwell, her defense started. Why are there so many secrets in this case? We'll talk about it next.
I also want to take this opportunity to thank all the many hundreds of people who have sent messages of support to us at this very, very sad time.
That was Ghislaine Maxwell in Spain after her father's death. No one is sending her necessarily messages of support now that she's on trial for being Jeffrey Epstein's confidant, assistant, lover, whatever. It's a strange relationship, but she's accused of the sex trafficking that Jeffrey Epstein was involved in. I mean, this is what the case is about. And it's time now to hear from the defense. And what was really interesting, at first, the list of witnesses was secret, was sealed, and then the defense wanted to do something else. Take a look. The defense on December 12, 2021 moved to permit 3 anticipated witnesses to testify under a pseudonym or their first names only. The defense's primary contention is that some form of anonymity for its witnesses is justified by the same reasons that the court permitted 3 alleged victims and 2 related government witnesses to testify under pseudonyms. The court disagrees with this basic premise and denies the defense's motion. So they didn't win it, but it was going to be more, secret witnesses in a case that's been very secretive. I mean, first of all, it's in federal court, so there's no cameras, right? But let me bring back in the think tank. And is this at all normal, Molly, that you've got both sides? And I understand the nature of some of the conduct here that's alleged. So sometimes we do protect the names of people who've been victims of sex assault, et cetera, or if they're young, whatever. But it just seems there's a lot of that permeating this entire case and trial.
I mean, federal cases are always a little bit more secretive because you don't have the cameras in the courtrooms, and they are more intimate. You don't have crowded courtrooms. You just really, every single hearing, you're going to just have the judges or the judge and the parties and the defendant. But in this case, you're right, Vinny. I mean, the reason that the alleged victims were allowed to testify under pseudonyms was because they are the alleged victims. And I think it's interesting that the defense counters by saying, hey, we should have some parity and some equity here. And I always think that that's a good argument. I mean, the U.S. Attorney's Office has incredible power and incredible resources, and there should be an even playing ground. But I understand why the judge denied the defense's motion. But who are these people going to be? I mean, we're at least going to find out. And I think that, the presentation from the defense, it could go in any direction. I was actually shocked that the government did not put on more testimony and evidence, that they finished their case in chief fairly quicker, certainly quicker than they said they were going to. And we have to remember that these charges are very nuanced and complex. It's conspiracy to entice minors to cross state lines with the intent to engage in either prostitution or another criminal act. And so there's a lot of elements that the government has to meet. And I don't know. I mean, I just feel like this is not straightforward at all. And certainly there's a chance that the defense is going to put on quite a riveting case, possibly one sufficient enough for a not guilty.
Renée Hill, this is your neck of the woods. Is this normal, what's happening in this trial? Because, you know, there's a lot of people out there saying, what are they hiding? Why are they doing this? Why don't we learn more about what's going on here? And of course, it all involves a huge conspiracy, is what a lot of people believe, because of Epstein and who he was connected to. Is that what you're seeing here, or is this what happens in federal court in your city of New York?
I mean, it happens here, you know, and yes, secrets, little black books, names that are probably in that book that people may be shocked to hear about could be the potential witnesses in this case. And at the end of the day, the defense has to protect their client, and they have to put forth the best case that they can. So they are not concerned about what the media thinks, what the public thinks. They should be allowed to know. They want to make sure that their witnesses are protected if they need to be protected, and that they can get in there and give the testimony that they need to give for this case. That's what they're doing, and they're doing a good job, I believe, or they will at least put forth their best foot forward. But this is a tough case for the defense, no matter what.
Here's one of the witnesses, Carmen. Simberly Espinosa, former office worker for Jeffrey Epstein, did not witness, she testified she did not witness misconduct by Maxwell while working closely with her for 6 years. Saw the accuser Jane visit Epstein's New York City office, and she was treated with the utmost respect. How much weight does the testimony of a former office worker come in? I mean, he's former office worker, you know, he doesn't have to work for Epstein anymore.
You know, the cross-examination was that she'd never been to any of the locations where these alleged incidents occurred. So her knowledge was clearly limited. She didn't even know and couldn't really testify to the depth of the relationship between Epstein and Maxwell. So, you know, clearly she was sheltered in this situation, which is probably why she's not part of any co-conspirator situation. But yeah, this case is bizarre. And while I appreciate creative defensive arguments, I don't know what witnesses need to come in under pseudonyms who are going to talk about, you know, this relationship between Maxwell and Epstein, or what they may or may not know about some of these complainants. But the federal judge made clear that, look, victims are given special protection, not just because they're victims, but because they're talking about sensitive, embarrassing sexual encounters. And unless these witnesses are coming in under the same circumstances, what they have to say doesn't require or should not warrant that level of secrecy, such as to give them a pseudonym or some other disguise so that everyone is unaware of who they are. So this is just going to keep getting interesting.
Yeah, and there was no truth to the rumor that one of them was going to be some guy, Bill? I don't know. Cannot verify that. There was another defense witness, Elizabeth Loftus, and we've seen her before in other trials, a cognitive psychologist who studies false, repressed, and unreliable memories. That's when the testimony is really bad, and you've got to figure out a way to get rid of the testimony that really hurts you. She testified that as memories fade, people become more vulnerable to post-event information like media reports, which can distort what they remember. Said people can become attached to false memories and be confident and emotional about them. What do you think about that, Molly? False memories.
Well, listen, I could talk about false memories all day, but, you know, especially as it relates to the wrongfully convicted. But in this case, what's interesting, so under federal law, there is no statute of limitations when it comes to sex crimes committed against minor victims. Same thing with electronic dissemination of child pornography. They can indict at any time these kind of crimes. And so in this case, you do have this huge gap in time from when these crimes allegedly committed to when we are in front of a jury going to trial. And so I do think that it makes sense for the defense to call an expert who's going to testify about how, given how many years, decades have elapsed, how perhaps these victims' recollection is not crystalline. The human brain does not work like a recorder. And the reason it's relevant is that it's not enough simply to show that Ghislaine Maxwell had a close friendship, a relationship with Jeffrey Epstein. She is charged in a conspiracy. You have to show that she agreed to enter the conspiracy with Jeffrey Epstein, that they had a shared common criminal objective. And so if they can separate her and do this through this expert, say, listen, the girls may remember Jeffrey Epstein, but the girls can't have a perfectly clear memory of Ghislaine Maxwell. Now we've taken her out. Mere presence is not enough for a conviction. Merely being there is not enough. She has to join the conspiracy. She has to have corrupt intent when these victims are moved across state lines. And that's why this expert is being presented. And that's why it could be very useful for the defense.
Okay. When we come back, we've got another criminal defendant who I think is indefensible, but we've got 3 great criminal defense attorneys. And I'm going to ask them one question. How do you defend her? The story of Letitia Stouk when we come back. Still ahead. On the docket tonight in El Paso County, Colorado, Letitia Stouk is accused of murdering her stepson Gannon because her husband wasn't paying enough attention to her. We have a preview of this heartbreaking trial.
I come before you today a broken man, celebrating the life of my precious, premature, and prepossessing son.
Plus, accused killer and former police officer Kim Potter says she will testify in her own defense. Tonight's 13th juror question: is there anything she can say that will change your mind about the case? Go to our Facebook pages and tell us what you think. On the docket tonight, the tragic murder of 11-year-old Gannon Stouk. Here's the story of his stepmother, Letitia. It begins with a 911 call at 6:55 p.m. on Monday, January 27th. Letitia told the operator Gannon was supposed to come home from a friend's house an hour ago, and she was unable to locate him. At the time, Gannon's father was out of town on reserve duty. A missing person investigation was opened up, and a community began to search for a little boy.
This was a kid that was very frequent out front, being very, being a kid, very playful, very funny.
Whatever we could do just to show them that we're thinking of them and, they're in our thoughts and prayers.
As the investigation continued, police began to question Letitia's story. They examined phone records, GPS records, home security system records, and a surveillance video from a neighbor's home.
Neighbor Roderick Drayton gave investigators his home surveillance video showing Gannon leaving with his stepmother, then returning without him on the day the child disappeared. He says he searched the video after seeing the stepmother interviewed.
It just didn't seem right the way she was talking. Okay. If my child is missing, I'm going to face the camera and talk to you. That you see the pain in my face.
In court, prosecutors spoke about the vast amount of evidence gathered during the investigation.
The last number that I heard was over 107 search warrants in this case. Yes, 107. 107. I think that number is bigger than that number, though, just based on that was last week sometime that I heard that.
These 107 search warrants uncovered a lot, including blood stains on Gannon's mattress, blood spatter on this electrical socket next to his bed, evidence of blood in the garage and near the bumper of Letitia's Volkswagen. Many of these blood samples were directly linked to Gannon's DNA. All this, enough to arrest Letitia, who was no longer in Colorado where Gannon went missing. Letitia was arrested on March 2nd in Myrtle Beach, South Carolina. Then, on March 20th, a huge development.
Now to breaking news at 5. It is believed that 11-year-old Gannon Stouk's remains have been found.
Gannon's remains were found not in Colorado, not in South Carolina, but in Florida, 15 miles north of Pensacola, near the Escambia River Bridge in a town called Pace.
Today I filed new formal charges in the case against Letitia Stouk. Those charges are murder in the first degree after deliberation, a Class 1 felony that carries a potential prison sentence of life in prison without parole. In addition to that, I've filed 8 counts of crime of violence for the alleged use of a firearm, a blunt instrument, a knife or other sharp object, and for causing the death of Gannon Stouk.
Letitia Stouk is presumed innocent, and according to the arrest affidavit, she has a story. She told investigators Gannon was abducted by a Hispanic man named Edgardo, who took Gannon at gunpoint after sexually assaulting Letitia inside the family's home. That's a story investigators don't believe, but the question is, will Letitia tell that story to a jury, and will a jury believe it? Or will they deliver the justice Gannon's family is looking for?
Let's bring back in our think tank tonight. 3 great criminal defense attorneys. Carmen Rowe, I'll start with you on this one. How do you defend Letitia Stouk?
This one's a tough one, Vinny, but I'd go one of 2 ways, if not both. First of all, you have the 17-year-old daughter who's refusing to talk to police. This could be a situation where mom's trying to cover up for her. Unlikely given some of the evidence that we've seen, but that's a possibility. So obviously you're going to go for reasonable doubt, focus on some of that disconnected evidence, and make the state show that there is a connection with her and no one else. I don't know if you can talk about Eduardo or not, whether that's real. Again, I think some of the evidence doesn't add up there, but I think this is a mitigation and a punishment case. So while I would go in on a guilt-innocence case, I would focus every bit of my energy on what is clearly mental health issues and other things that have exacerbated the situation, which makes her more sympathetic and ultimately may keep her out of prison for the rest of her life.
Renée Hill.
I completely agree. And I have written down here on my little pad, is there a mental health component here? Because I think that it is. And that's the way they're going to have to go with this case. From what we know, there is so much evidence here that points towards her. And again, the people have to prove it beyond a reasonable doubt. But if they can, and there's probably a lot that we don't know that they haven't shared with us yet, they're going to need to mitigate this case. They're going to need to do some sort of a PPI, a pre-pleading memo or something. They really should focus on that before going to trial. And if they can't, they're going to have to put it forth before the jury and try to get some sympathy for her, a reason for them to come back with a lesser included offense.
Molly Parmer, I'll give you one more little factoid. There's an alleged search that she did on the computer. When your husband turns you into a babysitter.
Well, Vinny, you act as though criminal defense lawyers consider the quantum of the evidence, and if it gets to be a certain amount, we just can't do it. That's not how it works, okay? In a case like this, look, my brilliant, esteemed colleagues, Renee and Carmen, they are right as usual. What we do in a situation like this, if they're not going to offer her any kind of deal, you don't plead somebody out to life. You are the person that ensures the Bill of Rights and constitutional due process is met by the government, and you stand beside the accused, the vilified, the hated, with all of the evidence against them, and you hold the government to their burden of proof. You walk through, and yes, you probably tried the case. Are you going to win? No, we lose a lot. But on the other side, like Carmen said, and like Renee said, you're the one who gets to know the client. We all have hearts, and I think brains and minds big enough to understand that they're still deserving of these rights. And we explain then to the judge and to the jury why the sentence should be maybe less than what we presume it should be by just looking at the facts and the evidence. But our work is far more, I think, complex than you're making it seem like, Vinny. And it's not simply the amount of evidence that decides whether or not we stand up for our clients.
Are you sending your investigator out to track down Edgardo?
Why not?
I mean, yeah, sure.
Talk to him. Find out what information he has.
We shall see. We shall see. We're still trying to determine her mental status right now. At one point, she was not competent to stand trial. She may be reevaluated. We will continue to track it for you. But right now, this is what we have on the docket right now. A motions hearing that is scheduled for January 13th of next year. Then a readiness conference in March. A trial date, March 28th. So as long as she remains competent to stand trial, it looks like she is going to trial at the end of March. All right. When we come back, we'll talk about a case that is on trial right now. Kim Potter, accused of manslaughter in the shooting death of Dante Wright. She has said twice now that she's going to take the stand. We expect her to testify tomorrow. We expect you'll be watching it right here on your front row seat to justice. Here's my question tonight, though. Is there anything that she could say that would change your mind about the case? Your answers, your verdict, next.
Your counsel had indicated before that you thought he thought that you wanted to testify. Do you understand that it is totally your decision as to whether or not you testify?
Yes, I do, Your Honor.
Okay. And is it your wish, have you had enough time to think about this?
Yes, ma'am.
And at this time, is it your wish to testify in this case?
This time I wish to testify.
Okay.
That was during jury selection of the case, and it was confirmed in court once again. So we expect tomorrow Kim Potter to take the witness stand in her own defense. So make sure you're watching CourtTV. So posted this news on social media and asked you, is there anything that she could say that would change your mind about the case? We begin with our 13th juror comment today, coming from Nicola. The only thing that would change my mind is if she said she did it on purpose. Acquittal all the way. Stop wasting time and money. Molly Parmer, what are your thoughts about Kim Potter on the witness stand? Is there anything that she could say at this point that would change your mind? I don't even know what you think of this. Uh-oh.
I don't like it. I thought the defense expert did so well, but I don't like the idea that this is acceptable force, that you can shoot to kill, that, deadly force is appropriate here. And so the thing that would change my mind is if she is likable. That's what I don't know. I mean, right now, no, I don't like her. So I wonder if she takes the stand, is she going to show this side that makes her so much more, provides more empathy for her? We'll see. But no, I don't think she's going to take the stand to that viewer's comment and say, I did it on purpose. I'm sure she's prepared well enough not to do that. So I would not be expecting that in the least.
Deborah, tonight, I'm looking forward to hearing from her. I truly believe with my heart the whole thing was a horrible accident. I don't think she intended to shoot and kill him. Renée Hill, is there anything that she can say that could change your mind about this case?
Again, like Molly said, I don't like her. I don't like the premise of this entire case, but I do believe that she is going to present well in front of this jury. I think she's going to be extremely sympathetic. She is very remorseful, and I think the jurors want to see it and hear it up close and personal. And she's going to present that way, and I think it's going to be very beneficial for her and for their argument that this was an accident. She truly would not be the kind of person to do something like this. And all of the officers who have testified about what a wonderful person she is, all of the programs that she's been a part of, all of the domestic violence victims that she has helped, all of these different things that she has done, so wonderful. She would never do anything to harm an individual. And I think that's all going to come out when she testifies as well.
Such a great point you made about remorse, because in most cases that we deal with here on CourtTV, a defendant can't show remorse because then you're kind of admitting that you did it. But we know that she did it. We saw it on the video. So it's what is it? Valerie tonight, I don't think she needs to testify because to me the state didn't do the job well for the charges she's facing. I do think it was accidental, but it also reckless and culpable negligence causing death. Carmen Rowe, your thoughts? Anything she could say that would change your mind?
I think the defense has done an amazing job of making this case less about the law and a whole lot more about emotion. So that's what they want to see from this defendant as she testifies. She needs to show remorse, and she needs to say this was out of character and I never would have done it had I known, which plays right into this accident theory that I don't know that the law supports, but I think that it drives home what the defense has been able to do in this case, which is the reasonable doubt that we all hope for in getting that not guilty verdict.
Eric, tonight, not sure how an officer with her length of service makes this kind of mistake. Most people pay some price for a mistake that takes another life, regardless of the victim. Feel sorry for her and the victim as well. Both should have made better decisions. One life is lost. One life is ruined. We have about 15 seconds here, Molly. Is there any way for her to pay a price without being convicted here?
Well, I think she's going to pay an emotional price. She has to carry this with her, even if she is acquitted. I mean, somebody is dead, and it was her, gun that did it. But I think, this idea of an accidental death being a not guilty, when else have we ever heard that? If you kill somebody and say it's an accident, you're still guilty, and that's the issue.
That's right.
All right, what a great job tonight. Renee Hill, Carmen Rowe, Molly Parmer, thank you so much. Appreciate it. Enjoy the holidays. We'll see you afterwards. Okay, folks, when we come back, there's a woman who's been missing down in Florida. It's been over a year. She's a mom. Her father will join us live.
In Hennepin County, Minnesota, the state rests in their case against former officer Kim Potter, and the defense starts calling witnesses, including a use of force expert who takes the stand to give the jury his opinion about when officers can take the life of a suspect. We are live with the latest.
Kim Potter's defense begins with experts and character witnesses talking about she's a good person, she was a good cop, and she followed procedure during the Daunte Wright shooting. Coming up, we'll preview what to expect next in her case.
In Fort Myers, Florida, new information revealed in the case of missing mom Lauren DeMolo. How